Before we begin, a quick and important disclaimer. The information provided in this video is for educational and entertainment purposes only and does not constitute professional legal, financial, or tax advice. Divorce laws, retirement account regulations, and tax codes are highly complex and vary significantly by state and individual circumstance. The historical trends and case studies discussed are intended to illustrate general concepts and should not be used as a substitute for the counsel of a qualified attorney or a certified financial planner. Every viewer must conduct their own due diligence and consult with a licensed professional regarding their specific situation before making any decisions related to asset division or retirement planning. In the year 2008, a couple sat in a wood-paneled mediation room in Northern Virginia. On Friday afternoon, they had finally agreed to split their primary marital asset, a 401k account valued at exactly $1 million. They shook hands on a 50-50 split. But by Monday morning, Lehman Brothers had collapsed, the Dow Jones Industrial Average was in freefall, and that $1 million had evaporated into $600,000 in a matter of trading hours. Suddenly, the agreement that felt fair on Friday became a financial death sentence for the spouse who was expecting $500,000, but was now legally tied to a percentage of a cratering fund. This was the reality of the 2000s in America, a decade defined by two massive market crashes and a total transformation of how we think about marital wealth. We are about to dive into the era where the 401k stopped being a future bonus and became the most volatile, dangerous, and misunderstood weapon in the American divorce court. If you think your retirement account is just a bank account with your name on it, you are making a mistake that cost thousands of families their entire life savings between 2000 and 2009. By the end of this masterclass, you will understand the hidden mechanics of the QDRO, the tax traps that the IRS used to claw back billions, and why the lost decade of the 2000s still dictates how divorce settlements are structured today. To understand the 401k divorce in the 2000s, we first have to understand the massive cultural and economic shift that preceded it. For decades, the American dream was built on the three-legged stool of retirement, Social Security, personal savings, and the defined benefit pension. In a pension world, divorce was relatively straightforward regarding retirement. You calculated the present value of a future monthly check. But by the dawn of the year 2000, the stool had lost a leg. Corporations were aggressively freezing pensions and forcing employees into defined contribution plans, specifically the 401k. This shifted the entire burden of investment risk from the employer to the employee. For a married couple, this meant their single largest pool of liquid wealth was no longer a guaranteed check from a company like General Motors or IBM. It was a fluctuating, market-exposed brokerage account sitting in a dashboard. When the dot-com bubble burst in early 2000, the divorce courts of America were caught completely off guard. We saw historical trends where settlements were drafted based on date of separation values, only to have the market drop 20% before the judge even signed the decree. Imagine a scenario where a husband is ordered to pay his ex-wife $100,000 from his 401k to equalize the assets. In a rising market, that is easy. But in 2001, by the time the paperwork cleared, the entire account might only be worth $90,000. The husband was now legally obligated to pay more than the account even held. This created a wave of litigation that redefined the concept of valuation dates. In U.S. law, we saw a shift from static dollar amounts to percentage-based distributions, a lesson learned the hard way through thousands of broken settlements. The most critical tool in this entire process, and the one that caused the most devastation in the 2000s due to simple clerical errors, is the Qualified Domestic Relations Order, or QDRO. A divorce decree issued by a state court judge is actually powerless to move money out of a 401k, because these accounts are governed by federal law, specifically the Employee Retirement Income Security Act of 1974, or ERISA. A state judge cannot tell a federal plan administrator what to do. The QDRO acts as the bridge. It is a separate legal document that must be drafted with surgical precision, sent to the plan administrator, and approved before a single cent moves. In the 2000s, the QDRO gap became a financial black hole. Couples would get divorced, think they were finished, and then wait months or even years to file the QDRO. During that gap, several things could happen. The participant spouse could retire, take a loan against the 401k, or simply lose half the value in a market downturn. Case studies from this era show that if the QDRO didn't explicitly state who was responsible for gains and losses during the processing period, the litigation could drag on for a decade. We saw instances where a spouse was awarded a specific dollar amount, But because the market grew during the 2 years it took to file the QDRO, the other spouse felt cheated out of the growth. Conversely, if the market crashed, the spouse receiving the money might find that their award had been wiped out because the plan administrator applied the losses to their share. Then, there is the issue of pre-tax versus post-tax reality, which is the single biggest trap for the uninitiated. In the 2000s, many couples made the mistake of trading the house for the 401k. Let's look at a step-by-step example. A couple has a house with $200,000 in equity and a 401k with $200,000 in it. It looks like a fair trade. One takes the house, the other takes the retirement. However, the house equity is often tax-free up to a certain limit upon sale, while every single dollar in that 401k is a ticking tax time bomb. When the spouse with the 401k goes to withdraw that money in retirement, they might only see $140,000 after federal and state taxes. In the eyes of the law in the early 2000s, these assets were often treated as equal in value, leading to a massive disparity in actual purchasing power post-divorce. Furthermore, the 2000s introduced a unique exception that many people today still don't realize exists. Under Internal Revenue Code Section 72T(2)(c), payments made to an alternate payee under a QDRO are not subject to the 10% early withdrawal penalty. During the mid-2000s, as the housing bubble began to stretch thin, many divorcing spouses used this QDRO loophole to access cash. If you were 35 years old and needed money for a down payment on a new post-divorce home, you could take your share of the 401k as a direct cash payment rather than rolling it into an IRA. You would still owe income tax, but that 10% penalty, which usually acts as a massive deterrent, was waived. This led to a significant leakage of retirement wealth during the decade, as people prioritized immediate liquidity over long-term stability. This masterclass is designed to solve the mystery of why your parents or older colleagues might still be bitter about their settlements from 20 years ago. It solves the problem of invisible math, the idea that a number on a screen is what you actually own. For the US audience today, understanding the 2000s is vital because we are seeing similar patterns of market volatility and the transition into new asset classes like HSAs and even cryptocurrency within retirement umbrellas. By studying the specific failures of the QDRO process during the Great Recession and the dot-com bust, you will learn how to protect your future self from the present stress of a legal battle. We are going to break down the exact language required to survive a market crash mid-divorce, the 3 questions you must ask your plan administrator before you even file for separation, and the historical data that proves why a 401k is often the most expensive asset you can win in a courtroom. This isn't just about history. It's about the blueprint for financial survival in a system that was never designed to be split in two. To understand why the 401k became a battlefield in the early 2000s, we have to look at the specific mechanics of how assets are valued during a legal separation in the United States. In the year 2026, we have automated software and real-time data feeds to track every cent, but in the early 2000s, the process was manual, slow, and prone to catastrophic timing errors. Let us examine the case of Michael and Jennifer, a couple living in a suburb of Chicago in the year 2001. Michael had been working for a telecommunications giant since 1992, and by the time they filed for divorce in early 2001, his 401k was sitting at a comfortable balance of $600,000. To the average observer, this looks like a simple math problem. 600,000 divided by 2 equals 300,000 each. But in the world of 401k litigation, that logic is a dangerous oversimplification. The first hurdle Michael and Jennifer faced was the determination of marital versus separate property. This is where we introduce the concept of the coverture fraction. In the early 2000s, this formula was the standard for high-stakes divorces involving retirement accounts. Michael had been contributing to his plan for 9 years, but he had only been married to Jennifer for 5 of those years. The court had to determine what portion of that $600,000 belonged to the marriage and what portion Michael brought into the relationship as his separate property. Under historical trends of that era, the calculation would look like this. The numerator is the number of months the couple was married while Michael participated in the plan, and the denominator is the total number of months Michael participated in the plan. In this case, 60 months of marriage divided by 108 months of total participation gives us a coverture fraction of roughly 55%. This meant that only $330,000 of the account was actually up for grabs in the divorce, while the remaining $270,000 was Michael's separate property. Imagine if Jennifer's attorney had not understood this math. If they had negotiated for a flat 50% of the total account based on the assumption that it was all marital, Michael could have faced a massive loss of his premarital savings. Conversely, if Michael had tried to hide the growth that occurred during the marriage by claiming the account was mostly premarital, Jennifer's forensic accountants would have had to dig through years of paper statements to prove the coverture fraction. This leads us to the valuation date trap, which was particularly lethal between 2000 and 2002. The dot-com bubble burst exactly as many couples like Michael and Jennifer were in the middle of their discovery phase. Let us say the valuation date was set as March 1, 2001. On that day, the marital portion was worth $330,000. Jennifer was awarded 50% of that, or $165,000. However, the legal system moves slowly. By the time the judge signed the decree and the QDRO was drafted and sent to the plan administrator in October 2001, the market had cratered. The total value of the 401k had dropped by 30%. Because the court order specified a fixed dollar amount of $165,000 rather than a percentage, Michael was forced to pay Jennifer her share out of a significantly smaller pool. He was essentially forced to bear 100% of the market losses himself, while Jennifer's share remained protected. This historical trend led to a massive shift in how attorneys wrote these documents, moving toward percentage-based awards that shared the market risk between both parties. Step by step, the process of dividing a 401k in the 2000s required a level of precision that few couples were prepared for. First, you had to obtain the summary plan description from the employer. This document outlined the specific rules of that individual 401k. Not all plans were created equal. Some plans in the early 2000s allowed for immediate distribution to an ex-spouse, while others required the ex-spouse to wait until the participant reached retirement age. If Jennifer needed that money to start her new life in 2001, and the plan rules stated she couldn't touch it until Michael turned 65, she would be in a dire financial position despite having won her share of the account. Next came the issue of 401k loans, which acted as a poison pill in many 2000s settlements. During the early 2000s, it was common for participants to take loans against their 401k to pay for home renovations or to consolidate debt. Imagine if Michael had taken a $50,000 loan 6 months before the divorce. On his statement, the balance shows as $600,000, but $50,000 of that is actually a debt he owes back to the account. If the divorce decree didn't account for this loan, Jennifer might find her share reduced because the loan balance is subtracted from the total available for distribution. Even worse, if Michael was laid off during the telecommunications industry's downturn, which was rampant in 2002, the loan would be triggered for immediate repayment. If he couldn't pay it back, it would be treated as a taxable distribution, and the resulting tax bill and penalties could eat up a significant portion of the remaining marital assets. We also have to consider the administrative burden. In the early 2000s, plan administrators were overwhelmed by the complexity of QDROs. It was not uncommon for a draft to be rejected 3 or 4 times because of a single missing word or an incorrect reference to a section of the plan. Each rejection could take 60 to 90 days to resolve. During this time, the assets remained in the participants' control. We saw case studies where a bitter spouse would intentionally shift the investment allocation of the 401k into high-risk, volatile stocks during the QDRO processing period. If the market went up, they kept the gains. If it crashed, they effectively burned down the house while the other spouse was still standing in the yard, waiting for the paperwork to clear. This era of bad faith investment tactics forced the courts to develop more stringent fiduciary duty standards during the pendency of a divorce. As we move deeper into this masterclass, we have to address the psychological toll of these financial mechanics. In the 2000s, the 401k was often the only thing left when the tech stocks failed and the house prices began to stagnate. It represented not just money but time. 10 years of 40-hour weeks were distilled into that one account. When the court system approached it with the cold, hard logic of coverture fractions and valuation dates, it often felt like a violation of that decade of work. The 2000s taught us that the number on your statement is a ghost. It is a flickering image of potential wealth that can be distorted by a single market swing or a poorly phrased legal sentence. But the story of the 2000s divorce doesn't end with the dot-com crash. There was a brief period of recovery, a false sense of security that led many to make even bigger mistakes as we approach 2008. We are moving into the era where the housing market and the retirement market became inextricably linked. People began using their 401ks as collateral for mortgages they couldn't afford, creating a house of cards that would eventually collapse with even more violence than the tech bubble. If you think the valuation date trap was bad in 2001, wait until you see what happened when the underlying companies in those 401ks started disappearing entirely. The next part of our deep dive explores the catastrophic intersection of the 2008 financial crisis and the divorce court, where the very definition of value was pushed to its breaking point. What happens when the 401k you are fighting over is invested in a company that no longer exists? What happens when the house is underwater and the 401k is the only life raft left? We are about to uncover the hidden reality of the underwater divorce, and why the lessons of 2008 are more relevant today than ever before. The mid-2000s in the United States were characterized by a deceptive sense of financial invincibility. Between 2003 and 2006, the housing market was on an upward trajectory that felt permanent, and 401k balances were recovering from the dot-com bust with aggressive gains. This era created a specific type of financial blindness in divorce negotiations. Couples weren't just dividing assets, they were dividing fantasies of future wealth. To understand the transition into the 2008 collapse, we must look at the case of David and Sarah, a couple in Phoenix, Arizona, who filed for divorce in early 2007. This was the exact moment the tectonic plates of the American economy began to shift, and their story serves as a masterclass in why the 401k is often the only real asset left when the smoke clears. In 2007, David and Sarah sat down with their lawyers to look at their balance sheet. They had a home valued at $500,000 with a $300,000 mortgage, leaving them with $200,000 in home equity. David also had a 401k account through his employer, a major regional bank, which was also valued at exactly $200,000. In the mind of a 2007 homeowner, these two assets were identical. They decided on a clean swap. Sarah would keep the house so the children didn't have to move, and David would keep his 401k. On paper, they both walked away with $200,000. This is what historical trends call the equality trap. Imagine if Sarah had realized that her $200,000 was locked in a physical structure in a declining market, while David's $200,000 was a liquid, albeit tax-deferred, financial instrument. As 2007 bled into 2008, the Phoenix housing market didn't just dip, it vanished. By the time their divorce was finalized in mid-2008, Sarah's house was appraised at $280,000. Because she still owed $300,000 on the mortgage, her $200,000 of equity had not just disappeared. It had turned into a $20,000 liability. She was now underwater. Meanwhile, David's 401k had also taken a hit as the financial sector crumbled, but it was still worth $140,000. This scenario highlights a brutal reality of 2000s-era divorces. The 401k has a floor, whereas a mortgaged home can have a basement. David had lost $60,000 of his balance, but Sarah had lost $220,000 of her net worth. The 401k during this period became the ultimate life raft, but it was a life raft surrounded by sharks in the form of IRS regulations and plan-specific hurdles. Let us break down the mechanics of the underwater offset. In 2026, we see similar volatility, but in 2008, the courts were forced to decide if a 401k could be used to balance out a negative asset. If Sarah's house was worth $20,000 less than the debt, should David have to give her $20,000 from his 401k just to bring her to zero? Most U.S. courts during this decade ruled that you cannot force an offset for a negative asset unless there is a specific contractual agreement. Sarah was left with a house she couldn't sell and a debt she couldn't pay, while David, though poorer than he was a year prior, still held a six-figure retirement account. This leads us to the hidden danger of 401k loans during a market meltdown. Historical trends show that during the mid-2000s, many Americans treated their 401ks like a revolving line of credit. David had taken out a $40,000 loan from his 401k in 2006 to help with the down payment on a second property, a common move during the real estate frenzy. When the financial crisis hit in 2008 and David's bank began a round of massive layoffs, David lost his job. Under the plan rules of that era, a 401k loan must typically be repaid in full within 60 to 90 days of leaving the company. If David couldn't pay it back, and he couldn't because his savings were tied up in the divorce, the IRS treated that $40,000 as a deemed distribution. Step by step, the disaster unfolded. The $40,000 was added to David's taxable income for the year, pushing him into a higher tax bracket just as he lost his salary. Because he was only 45 years old, he was also hit with a 10% early withdrawal penalty. That $40,000 loan suddenly cost him nearly $15,000 in taxes and penalties. In the divorce settlement, Sarah's lawyer argued that the 401k should be valued at its gross amount before the loan. David argued it should be valued net of the loan. This distinction of a few words in a legal document determined whether David owed Sarah an additional $20,000 he didn't have. Another layer of complexity that reached a breaking point in the 2000s was the issue of company stock within the 401k. Many employees at firms like Bear Stearns, Lehman Brothers, or even Enron earlier in the decade had their 401ks heavily weighted in their own company's shares. When those companies collapsed, the 401k didn't just lose value, it ceased to exist. Case studies from 2008 show divorcing spouses fighting over the projected value of an account that was essentially a corpse. If a QDRO was written to give Sarah 50% of David's Lehman Brothers stock fund, and that fund went to zero before the transfer was completed, Sarah received 50% of zero. The courts had to grapple with whether the participant spouse had a fiduciary duty to diversify the account during the divorce to protect the ex-spouse's interest. Generally, the answer was no, unless the court order explicitly required it. Imagine if you were the spouse waiting for your QDRO to be processed while watching the news in September 2008. You see the global financial system teetering on the edge. You know you were awarded $100,000, but you also know that your ex-spouse has the account invested in high-risk mortgage-backed securities funds. This era taught us the segregated account lesson. The only way to truly protect an interest in a 401k during a divorce is to move the award into a separate, segregated account within the plan as quickly as possible. But in the 2000s, the administrative backlog was so great that this segregation could take months. During those months, the alternate payee, the ex-spouse, was a passenger on a ship they didn't control, steered by an ex-partner who often had no incentive to navigate safely. The 2000s also highlighted the tax shadow of the 401k. Every dollar in a traditional 401k is shared with the government. If you are in a 25% tax bracket, a $100,000 401k is really only worth $75,000. In the heat of 2008's desperation, many people ignored this. They saw the big number and fought for it, only to realize years later that they had traded a tax-free asset, like a bank account or a portion of home equity, for a tax-deferred asset that would eventually be gutted by the IRS. This was the era of the gross-up negotiation, where savvy attorneys began demanding more than 50% of a retirement account to account for the future tax liability, a practice that became standard but was often missed by those trying to handle their own pro se divorces to save money. We are now moving into a territory where the 401k isn't just a pool of money, it's a legal minefield of beneficiary designations. What happens if the divorce is finalized, but the participant dies before the QDRO is signed? In the mid-2000s, this created some of the most heartbreaking legal battles in U.S. history. The Supreme Court eventually had to step in to decide who gets the money: the ex-spouse named in the divorce decree, or the new spouse named on the 401k beneficiary form. The answer changed the way every single retirement account in America is handled today. We are about to explore the Kennedy versus Plan Administrator fallout and the ghost beneficiary trap that can strip a 401k away from an ex-spouse, even after a judge has ruled it belongs to them. The next part of our masterclass will reveal why your divorce decree might be a worthless piece of paper if you don't understand the federal preemption rule. The federal preemption rule is the invisible wall that thousands of Americans crashed into during the 2000s, and it remains the single most misunderstood aspect of retirement asset division today. To understand why your state divorce decree might be functionally useless without federal compliance, we have to look at a concept known as ERISA preemption. ERISA, or the Employee Retirement Income Security Act of 1974, is a federal law that governs most private sector 401k plans. In the hierarchy of American power, federal law sits above state law. When a state judge in a local family court signs a divorce decree, they are operating under state law. However, the administrator of a 401k plan is bound by federal law. This creates a lethal jurisdictional gap that swallowed entire life savings during the mid-2000s. Let us examine a case study that eventually made its way to the United States Supreme Court, changing the landscape of divorce forever. Kennedy versus Plan Administrator for DuPont Savings and Investment Plan. Imagine a man named William Kennedy, a longtime employee of DuPont. In 1974, he married Liv Kennedy and named her as the sole beneficiary of his 401k style savings and investment plan. Fast forward to 1994, the couple decides to divorce. In the formal divorce decree signed by a state judge, Liv explicitly waived her right to any interest in William's retirement benefits. This was a clear, negotiated settlement where she received other assets in exchange for giving up her claim to the 401k. For the next decade, William lived his life under the assumption that the legal matter was settled. He never updated the beneficiary designation form on file with DuPont's HR department. When William passed away in 2001, a legal firestorm ignited. William's daughter, acting as the executrix of his estate, claimed the 401k funds based on the divorce decree's waiver. However, DuPont, following federal ERISA guidelines, pointed to the beneficiary form from 1974 that still listed the ex-wife Liv. DuPont paid the $400,000 directly to the ex-wife, despite the fact that she had legally waived her right to it 7 years prior in a court of law. This went all the way to the Supreme Court in 2009. The court ruled unanimously that the plan administrator was required to follow the plan documents, specifically that old beneficiary form, rather than the state divorce decree. This is the plan documents rule. It states that the administrator's only duty is to follow the paperwork held by the plan, not to investigate outside legal disputes or interpret state court orders. This case study sent shockwaves through the U.S. legal system in the late 2000s because it proved that a divorce decree is not a self-executing document. Imagine if you are a spouse in 2026, looking back at a settlement from the 2000s. If the beneficiary forms were not updated or a QDRO was not properly served, the money might have gone to a ghost from the past. This historical trend highlights a terrifying reality. The HR filing cabinet in a corporate office in Delaware or Texas held more power over a family's wealth than the robe of a state judge. Step by step, the failure points in these 2000s cases were almost always administrative. The first step was the belief that the divorce decree was the final word. It wasn't. The second step was the failure to understand that a waiver is not the same as a removal. In the eyes of federal law, Liv Kennedy's waiver in the divorce decree was an off-plan agreement. Because it was not submitted as a qualified domestic relations order, it did not meet the federal requirements to override the plan's own beneficiary designation. This is why the QDRO is the only skeleton key that can unlock the federal gate. Without it, the plan administrator is legally shielded, and in fact legally mandated, to ignore your divorce settlement. The 2000s were also the era of the interpleader action, when plan administrators found themselves caught between an ex-spouse named on a form and an estate pointing to a divorce decree. They didn't want to be sued for paying the wrong person. They would file an interpleader, which essentially means they hand the money over to a federal court and say, "You decide who gets this, we are out." This resulted in years of high-cost federal litigation that often ate up 20 to 30% of the account's value in legal fees alone. We saw instances where a $200,000 401k was reduced to $140,000 simply because the parties had to fight over the definition of a beneficiary in a federal circuit court. Another critical layer of this deep dive is the 2000s era transition to digital record keeping. In the early part of the decade, many 401k plans were still moving away from paper beneficiary cards. During this transition, many cards were lost, or the digital data didn't reflect the most recent paper updates. If a couple divorced in 2003 and the participant thought they updated their beneficiary online, but the system had a glitch or the company changed providers, which was common during the corporate merger mania of the mid-2000s, the old paper card from 15 years prior would suddenly reappear like a financial poltergeist upon the participant's death. For the US audience today, the lesson from this era is the concept of the double check. In 2026, we assume everything is synced, but the 2000s taught us that the 401k is a siloed asset. It exists in its own legal universe. If you were a stay-at-home parent during that decade, your financial security depended entirely on whether your attorney understood that a 401k is not a bank account. In a bank account, a death certificate and a divorce decree might be enough to move funds. In a 401k, those documents are often secondary to a single piece of paper signed in an orientation meeting 20 years ago. Furthermore, we must address the nunc pro tunc orders of the late 2000s. This Latin term means now for then. As the fallout from the Kennedy case and similar rulings became clear, attorneys scrambled to get judges to sign retroactive QDROs for participants who had already died. They were trying to fix the mistake after the fact. However, the historical trends show that these were rarely successful. Federal courts generally held that once a participant dies, the rights to the benefits are vested in the named beneficiary, and a state court cannot retroactively change the past to strip those rights away. This created a permanent loss of generational wealth for families who thought they had a solid settlement. Imagine if your entire inheritance depended on whether a clerk in an HR office stamped a document on a Tuesday in 2005. That is the level of granularity we are talking about. The 2000s was the decade where the technicality became the reality. As we continue this deep dive, we have to look at what happens when the money actually does move. Because even if you win the battle of the beneficiary forms and the QDRO, you still have to face the ultimate silent partner in every American marriage, the Internal Revenue Service. The 2000s saw a massive increase in tax audits related to early distributions from 401ks during divorces. People were so desperate for cash during the 2008 crash that they triggered tax bills they didn't understand, leading to a secondary collapse of their post-divorce finances. The next part of our masterclass will reveal the hidden tax codes that the IRS used to reclaim billions from divorcing couples and the specific Section 72 strategies that could have saved them. What you don't know about the net unrealized appreciation rule could cost you more than the divorce itself. The Internal Revenue Code is the silent executor of every divorce settlement in the United States, and in the 2000s, its influence was never more potent than when dealing with the division of a 401k. When we talk about the Internal Revenue Service, we are talking about a partner that owns a significant portion of your retirement account through deferred taxes. During a divorce, many couples made the catastrophic mistake of looking only at the gross number on the statement. If the account said $400,000, they assumed they were fighting over $400,000. In reality, they were fighting over a net amount that was often 30 to 40% lower once the federal and state governments took their share. This is where Section 72 of the tax code becomes the most important document in the room, specifically Section 72(t)(2)(c). In the mid-2000s, a historical trend emerged where divorcing spouses were desperate for immediate liquidity. The housing market was peaking, or in the latter half of the decade, crashing, and people needed cash to secure new housing or pay off mounting legal bills. Normally, if you are under the age of 59 and a half and you take a distribution from your 401k, the IRS hits you with two things: ordinary income tax and a 10% early withdrawal penalty. However, there is a specific exception carved out for a distribution made to an alternate payee pursuant to a qualified domestic relations order. This is the Section 72(t)(2)(c) exception. Imagine a scenario with a character named Lisa in the year 2005. Lisa is 42 years old and is being awarded $200,000 from her husband's 401k. Her lawyer gives her two options: roll the money into a new individual retirement account or take it as a cash distribution. If Lisa rolls the money into an IRA, she maintains the tax-deferred status of the funds, but she also traps that money behind the 59.5 age wall. If she needs $20,000 for a down payment 3 months later, she will have to pay the 10% penalty to get it out of that IRA. But if she takes that $20,000 directly from the 401k as part of the initial QDRO distribution, the 10% penalty is waived. This was a vital financial strategy in the 2000s, but it came with a massive trap that caught thousands of people off guard: the mandatory 20% withholding. Under U.S. tax law, if a plan administrator pays out a distribution directly to a participant or alternate payee, rather than rolling it into another qualified plan, they are legally required to withhold 20% for federal income taxes. Step by step, Lisa's $200,000 award could dwindle rapidly. If she decided to take the full amount in cash to start over, the plan administrator would immediately send $40,000 to the IRS. Lisa would receive a check for $160,000. Many people in this era saw that check and spent it, forgetting that 20% is just a down payment on the final tax bill. If Lisa was in a high tax bracket, say 33%, she would still owe another 13% of that $200,000 at the end of the year. In 2026, we look back at these case studies and see the trail of tax liens that followed the 2000s divorce boom because people failed to account for the secondary wave of taxation. Beyond the standard income tax, the 2000s were the era of net unrealized appreciation, or NUA. This is one of the most complex and potentially lucrative tax strategies in the entire Internal Revenue Code, and it applies specifically to employer stock held within a 401k. During the 2000s, many major U.S. corporations like General Electric, Procter & Gamble, or Pfizer encouraged employees to load their 401ks with company stock. When a divorce occurred, the division of this stock offered a unique opportunity that was often missed by general practice attorneys. Net unrealized appreciation is the difference between the original cost of the stock when it was purchased by the plan, known as the basis, and its current market value. Imagine if Lisa's husband had $200,000 worth of company stock in his 401k that was originally purchased for only $20,000 years ago. If Lisa receives this stock as part of the divorce, she has two paths. Path 1 is to roll it into an IRA, where it eventually gets taxed as ordinary income upon withdrawal. Path 2 is to use the NUA strategy. Under NUA rules, Lisa could take a distribution of the actual stock and move it into a regular taxable brokerage account. She would pay ordinary income tax immediately, but only on the $20,000 basis. The remaining $180,000 of appreciation would be taxed at the much lower long-term capital gains rate whenever she decided to sell the stock. In the mid-2000s, the gap between ordinary income rates and capital gains rates was massive. Using NUA could result in potential outcomes where the spouse kept thousands of dollars more of the settlement that would have otherwise gone to the government. However, the NUA strategy is a one-shot deal. It must be a lump sum distribution of the entire balance of the account in a single tax year. If Lisa took even a small portion of the 401k as a cash rollover to an IRA, and then tried to do an NUA distribution with the rest later, she would disqualify the entire strategy. Historical trends show that very few divorcing couples in the 2000s had the sophisticated tax advice required to execute this correctly. They would often sell the stock within the 401k to simplify the math for the divorce and then split the cash, effectively destroying the NUA benefit and triggering the highest possible tax rates for both parties. This brings us to the psychological and tactical warfare of the 401k tax liability. In many 2000s era negotiations, the spouse who was the primary earner would often try to trade other assets to keep the 401k. They understood that $1 in a savings account was worth more than $1 in a 401k. They would offer the house or the cars in exchange for the retirement account, knowing that they were effectively shifting the tax-free assets to the other spouse while they kept the tax-burdened asset. But they were betting on their ability to manage that tax bill over 30 years. When the 2008 crash hit, that bet turned sour. Those who fought to keep the 401k suddenly saw the account value drop by 40%, but the tax liability remained on every dollar that was left. They were paying a premium for an asset that was shrinking. We must also consider the role of the 1099-R form. In the 2000s, communication between plan administrators and divorcing spouses was notoriously poor. An alternate payee would receive their distribution in June, and they wouldn't receive the 1099-R until the following January. By then, the money was often gone. This created a cycle of financial instability where the win of the divorce settlement became the loss of the following tax season. Case studies from 2008 and 2009 show a spike in bankruptcy filings that were directly tied to unpaid taxes from 401k distributions taken during a divorce. As we move forward, we have to look at the darker side of these numbers. We have discussed the tax traps and the legal hurdles, but what happens when one spouse decides to take matters into their own hands? In the high-stakes environment of the 2000s, retirement dissipation became a common phrase in the courtroom. This is where one spouse, sensing the end of the marriage, begins to systematically drain or sabotage the 401k before the other spouse can even file for divorce. We are about to dive into the world of asset hiding, bad faith loans, and the scorched earth investment strategies that people used to ensure that when the 401k was finally split, there was nothing left to divide. What are the red flags you should have looked for in your quarterly statements? And how did forensic accountants track money that had been lost in the market? The next part of our masterclass will reveal the tactics of the 401k saboteur and the legal shields used to stop them. Retirement dissipation is the financial equivalent of burning down a house to ensure your spouse cannot live in it. In the high-stakes environment of the 2000s, where the 401k was often the last remaining pillar of wealth after the housing market began to crack, the temptation to sabotage this asset became a recurring theme in U.S. family courts. To understand how a 401k saboteur operates, we must first define the legal concept of waste or dissipation. This occurs when one spouse uses marital property for their own benefit, for a purpose unrelated to the marriage, at a time when the relationship is undergoing an irreconcilable breakdown. In the 2000s, the tactics used to drain these accounts evolved alongside the complexity of the financial products themselves. Imagine a character named Robert in the year 2004. Robert is a middle manager at a logistics firm in Ohio. He has spent 15 years building a 401k balance of $400,000. When his wife, Maria, mentions the word divorce, Robert does not seek a mediator. Instead, He logs into his retirement portal. He knows that once a divorce petition is filed, many states trigger an automatic temporary restraining order, or ATRO. This is a legal freeze that prevents both parties from hiding, transferring, or disposing of marital assets without court permission or written consent. Robert decides to act in the shadow period, the weeks or months between the realization that the marriage is over and the actual legal filing. The first tactic in the saboteur's handbook is the predatory loan. Historical trends show that 401k loans were frequently weaponized during this era. Robert takes the maximum allowable loan, 50% of his vested balance, up to $50,000. He claims the money is for home repairs that never happen. Instead, he places the cash in a safe deposit box, or moves it into an account held by a family member in a different jurisdiction. When the divorce proceedings eventually begin, the 401k statement shows a balance of $350,000 with a $50,000 debt attached. Robert's goal is to force Maria to share the burden of that debt, or to reduce the net value of the asset that is available for division. In the mid-2000s, if the court could not prove the money was spent on non-marital purposes, the alternate payee often ended up receiving a share of a significantly depleted account. The second, more aggressive tactic is the scorched earth investment strategy. This was particularly prevalent during the market volatility of 2001 and 2008. If a spouse feels they are going to lose half of their retirement regardless of what they do, they may decide to gamble the entire account on high-risk options or speculative stocks. In 2002, a saboteur might have moved a stable, diversified portfolio into high-leverage tech stocks that were already in a death spiral. If the investment succeeded, they might try to hide the gains. If they failed, as they often did, the spouse would simply tell the court that the market ate the money. Because judges are generally reluctant to punish a party for bad investment choices, viewing them as a shared risk of the marriage, this was a difficult tactic to combat. It required a high burden of proof to show that the investment was made with the specific intent to deprive the other spouse of their interest. Step by step, the defense against these tactics in the 2000s involved the precision of forensic accounting. A forensic accountant is a financial detective who looks past the balance sheet to find the story behind the numbers. In Robert's case, Maria's legal team would start by requesting 5 years of 401k statements, not just the most recent one. They would look for a sudden shift in investment philosophy that coincided with the marital strife. They would track the $50,000 loan from the 401k to the bank account and then follow the paper trail to see where that money landed. In 2005, this was a labor-intensive process of subpoenaing bank records and cross-referencing withdrawal slips with lifestyle expenses. When dissipation was proven, the court utilized a mechanism known as the add-back. This is a vital legal shield for the protected spouse. The judge would essentially perform a mathematical fiction. If Robert blew $50,000 on a luxury vacation with a new partner, the judge would add that $50,000 back into the marital pot. If the remaining 401k balance was $350,000, the court would treat it as if it were still $400,000. When it came time to divide the asset, Maria would receive her 50% share of the full $400,000, which is $200,000. Robert would be left with the remaining $150,000. Through this historical trend, the law attempted to ensure that the spouse who stayed within the rules was not penalized for the other's bad faith. However, the 2008 financial crisis added a layer of complexity that nearly broke the add-back system. Case studies from that year show that it became incredibly difficult to distinguish between legitimate market losses and intentional dissipation. If a 401k lost 30% of its value in the October 2008 crash, a spouse could easily hide their own mismanagement within the global chaos. This led to the rise of the fiduciary duty claim in family law. The argument was that during the pendency of a divorce, the spouse whose name is on the 401k has a legal obligation to manage those funds as a trustee for the benefit of the marital estate. If they failed to maintain a prudent investment strategy during the divorce, they could be held liable for the losses even if they didn't technically steal the money. We also have to examine the hardship withdrawal trap. In the 2000s, the IRS allowed 401k participants to take money out for specific heavy financial needs, such as preventing eviction or paying for medical expenses. Saboteurs would often forge the other spouse's consent or provide fraudulent documentation to the plan administrator to trigger these withdrawals. Unlike a loan, a hardship withdrawal cannot be paid back. It is a permanent reduction of the account, and it triggers immediate taxes and penalties. For a spouse like Maria, discovering that the retirement account has been raided via a hardship withdrawal is a double blow. The money is gone, and the marital estate is now burdened with a massive tax bill. For the U.S. audience in 2026, the lesson here is the importance of the early audit. The 2000s taught us that you cannot wait until the end of the divorce to look at the retirement accounts. You must monitor the statements from the moment the relationship becomes unstable. If you see a loan being taken or a radical change in how the funds are allocated, it is a signal to seek a court-ordered freeze immediately. These historical trends prove that the 401k is only a safe asset if both parties are acting in good faith, and the moment that faith evaporates, the account becomes a target. As we move toward the next phase of this masterclass, we have to look at what happens when the 401k is finally divided and the money is moved. This is the moment of the direct rollover, and it is the stage where a different kind of error can occur, one that doesn't involve malice but simple administrative failure. What happens when the money leaves the employer's plan but never arrives in the ex-spouse IRA? What are the lost assets of the 2000s, and how can you find money that was supposedly transferred 20 years ago, but has since disappeared into the abyss of corporate mergers and defunct brokerage firms? We are about to explore the world of unclaimed retirement property, and the specific steps you must take to ensure your share of the 401k actually makes it into your hands. The next part will uncover why thousands of 2000s-era divorcees are still technically owners of accounts they have completely forgotten about. The concept of the lost 401k from the 2000s is not a myth. It is a multi-billion-dollar reality that stems from the most volatile period of corporate restructuring in American history. To understand why your share of a retirement account might be sitting in a digital purgatory, we have to look at the massive wave of mergers, acquisitions, and bankruptcies that defined the decade. Between 2000 and 2009, thousands of companies that were household names simply ceased to exist, and with them, the direct lines of communication between plan administrators and ex-spouses were severed. If you were awarded a portion of a 401k in 2004 and you are just now looking for it in 2026, you are not just looking for money, you are performing financial archaeology. Let us consider a case study involving a character named Sandra, who divorced her husband, Mark, in 2005. At the time, Mark worked for a mid-sized telecommunications company called Northlink. The divorce decree and the subsequent qualified domestic relations order awarded Sandra $50,000 of Mark's Northlink 401k. However, Sandra moved to a different state shortly after the divorce and changed her phone number. In 2007, Northlink was acquired by a larger conglomerate. In 2009, that conglomerate filed for Chapter 11 bankruptcy. During these transitions, the 401k plan was moved from one financial institution to another, first from a small regional bank to a national provider, and then eventually into a terminated plan status. Because Sandra never updated her contact information with the plan administrator, the notices regarding these changes never reached her. She became what the Department of Labor calls a missing participant. In the mid-2000s, this was a rampant problem because the infrastructure for tracking mobile employees and their ex-spouses was fragmented. When a company merges, the 401k plan often undergoes a plan termination or a merger into the new parent company's plan. If a plan is terminated, the administrator is legally required to distribute the assets. For a missing participant like Sandra, the administrator would typically take one of two actions based on the historical trends of that era. If her balance was under $5,000, they might have utilized the automatic rollover rule established by the Economic Growth and Tax Relief Reconciliation Act of 2001, which went into effect for distributions on or after January 1, 2005. This rule allowed employers to force out small accounts into an individual retirement account or IRA in the participant's name without their consent. However, since Sandra's award was $50,000, it was above the force-out threshold. In many case studies from the late 2000s, these larger orphaned accounts were left in the plan, but the administrative fees began to eat away at the balance. Even worse, if the plan administrator could not locate the participant or the alternate payee, the funds might have been transferred to a state's unclaimed property fund. Though ERISA-governed 401k plans often have a complex relationship with state escheatment laws. This creates the first step of your deep dive: the search for the plan sponsor. If the company no longer exists, you must use the Department of Labor's Employee Benefits Security Administration search tool to find the most recent Form 5500 filing. This form is the tax return for the 401k plan and will list the name and address of the current plan administrator, even if the original company is a ghost. Imagine if Sandra had stayed in her original home, but the mail was simply lost. The 2000s were the era of the paper check. Before the widespread adoption of direct electronic transfers between 401k plans and IRAs, many distributions were handled by mailing a physical check to the alternate payee. If that check was mailed to an old address and never cashed, the money didn't just disappear. It was held in a non-interest-bearing account by the financial institution. In 2026, finding this money requires checking the National Registry of Unclaimed Retirement Benefits. This is a nationwide database where employers can register the names of former employees and ex-spouses who have unpaid benefits. It is a vital resource for anyone who suspects a 401k transfer from the 2000s never reached its final destination. Step by step, the process for recovering a lost 401k from this era involves 5 critical actions. First, you must locate your original court-certified copy of the Qualified Domestic Relations Order. Without this, no plan administrator will even talk to you. Many people from the 2000s make the mistake of thinking the divorce decree is enough. As we established earlier, the QDRO is the only document with federal teeth. Second, you must identify the current custodian of the plan assets. This might involve tracing a chain of corporate mergers. For example, if the 401k was with Washington Mutual in 2008, you would need to follow the trail to JP Morgan Chase, which acquired WAMU's assets after its historic failure. Third, you must verify if a distribution was ever processed. This is where the 1099-R forms come into play. If the IRS has a record of a 1099-R being issued in your name in, say, 2007, it means the money was moved. If you never received it, you may be looking for a stale-dated check. Fourth, you must account for the impact of administrative fees. In the 2000s, many 401k plans had tiered fee structures. If an account was left dormant for 20 years, those fees could have significantly reduced the balance. Finally, you must address the tax implications of finding this money today. If you recover $50,000 that should have been rolled over in 2005, the IRS may view the recovery as a current year distribution, unless you can prove it was a mistake and perform a late rollover under specific hardship waivers. The 2008 financial crisis added a final brutal layer to this administrative chaos. When major institutions like Lehman Brothers collapsed, the record-keeping systems were often the last priority. We saw case studies where the paper trails for 401k beneficiaries were literally lost in the shuffle of liquidation. If you were an ex-spouse of a Lehman employee in 2008, your claim was tied to a plan that was being managed by a court-appointed trustee. Recovering those funds required a level of persistence that many people simply didn't have during the stress of the recession. For the U.S. audience today, the hidden reality is that there are billions of dollars in these orphaned accounts. The 2000s was the decade of the transition from analog to digital, and millions of people fell through the cracks of that transition. If you are sitting on a 20-year-old divorce decree and you haven't checked on those funds, you are potentially ignoring a significant portion of your net worth. But finding the money is only half the battle. Once you find it, you have to deal with the fact that the laws governing these accounts have changed since the 2000s. The next part of our masterclass moves from the administrative to the strategic. We are going to look at the long-term impact of the 401k division on your Social Security benefits. Most people don't realize that the decisions you made in a 2005 401k negotiation can directly affect the amount of your Social Security check in 2026 and beyond. What is the hidden link between your retirement account and the government's monthly payment? And how did the 2000s era Social Security offset strategies backfire on thousands of retirees? We are about to uncover the connection that most divorce attorneys completely overlook. The intersection of Social Security and the 401k is where the most sophisticated legal minds of the 2000s either made their reputations or committed their greatest professional oversights. While a 401k is a private contract governed by ERISA, Social Security is a federal entitlement governed by the Social Security Administration under the Social Security Act. This distinction is critical because under federal law, Social Security benefits are not considered marital property. A state judge has zero authority to order the Social Security Administration to split a future monthly check between two ex-spouses. This created a massive problem for equitable distribution in the early 2000s. If one spouse had a 401k worth $500,000 and the other had nothing, but the higher-earning spouse was also expected to receive maximum Social Security benefits while the other would receive very little, how could a court make the split fair? This led to the rise of the Social Security offset strategy, a historical trend that defined high-asset divorces in states like Pennsylvania, Ohio, and Illinois during the mid-2000s. To understand how this works, imagine a character named James and his wife, Linda, in the year 2006. James is a senior engineer with a 401k valued at $600,000. Linda has spent the last 15 years working part-time or managing the household, so her own Social Security primary insurance amount is projected to be very low. In a standard 50-50 split, each would take $300,000 from the 401k. However, James's attorney argues that this is unfair. Why? Because James has been paying into Social Security at the maximum level for decades. His future Social Security benefit is an invisible asset, worth hundreds of thousands of dollars that Linda cannot touch directly. In the 2000s, courts began using the Kornbleth method or the Kelly method to quantify this invisible asset. Step by step, James's forensic accountant would calculate the present value of his future Social Security benefits. Let us say that at age 67, James is projected to receive $2,500 a month. Using a life expectancy table and a discount rate common in 2006, the accountant might determine that the present value of that stream of income is $350,000. The court then looks at Linda's projected benefit, which might only have a present value of $100,000. The Social Security gap is $250,000. In an offset scenario, the court might decide to credit James for this gap. Instead of splitting the $600,000 401k equally, the court might allow James to keep a larger share of the 401k to balance out the fact that Linda will eventually collect spousal benefits on his record without reducing his own check. This is where the 10-year rule becomes the ultimate trap for the unwary. Under federal law, an ex-spouse can only collect Social Security benefits based on their former partner's earnings record if the marriage lasted at least 10 consecutive years. In the fast-paced, high-stress culture of the 2000s, we saw a tragic number of case studies where couples finalized their divorce at 9 years and 11 months. By missing that 10-year mark by a single month, Linda loses the right to collect spousal benefits that could be worth 50% of James's full retirement amount. If the 401k was divided with the assumption that she would get those benefits, but the marriage ended too early, Linda is left with a smaller 401k share and no Social Security safety net. Imagine if you are Linda in the year 2026. You are looking back at your 2006 divorce settlement. You agreed to take only $200,000 of the 401k while James kept $400,000, because the offset math said you would be fine once Social Security kicked in. But because the divorce was finalized 30 days before your 10th anniversary, you are now facing retirement with a depleted 401k and a Social Security check that is half of what you expected. This potential outcome was a silent killer of financial stability for thousands of women in the 2000s who didn't understand that state judges cannot override federal Social Security durations. Furthermore, the 2008 financial crisis exposed the volatility of the 401k offset strategy. When the market crashed, the present value of James's 401k might have dropped from $600,000 to $350,000. However, the present value of his Social Security benefit remained relatively stable, because it is backed by the federal government and adjusted for inflation. James, who fought to keep more of the 401k in exchange for Linda getting credit for his Social Security, suddenly found himself holding a shrinking asset while Linda's invisible credit remained intact. This created a wave of 2009-era litigation where participants tried to move for a modification of judgment based on the market collapse. In most U.S. jurisdictions, however, once a property division is final, it is final. You cannot go back and ask for more of the 401k just because the stock market didn't perform as well as your Social Security projections. We also have to discuss the Government Pension Offset, GPO, and the Windfall Elimination Provision, WEP, which added a layer of nightmare complexity to 2000s divorces involving teachers, police officers, or federal employees. Many of these professionals had a 401k style plan like a 403b or a TSP, but did not pay into Social Security. If a teacher was divorcing a corporate executive, the Social Security offset math became nearly impossible. If the executive's 401k was split 50-50, but the teacher also had a pension that reduced their Social Security spousal benefits due to the GPO, the teacher could end up in poverty. Historical trends show that many 2000s attorneys simply ignored these provisions because they were too complex to calculate without specialized software that didn't exist for the average law firm at the time. The data from this era suggests that the Social Security offset was often used as a weapon by the higher earner to protect their 401k. By convincing a judge that their future Social Security check was a gift to the ex-spouse, they were able to walk away with the lion's share of the liquid, investable cash in the 401k. This cash, if invested during the recovery of 2010 to 2020, grew exponentially, while the Social Security benefits, though stable, never offered that kind of wealth-building potential. For the U.S. audience today, the lesson is clear. Never trade a liquid $401,000 for a projected Social Security dollar without accounting for the massive difference in growth potential and the absolute strictness of the 10-year federal clock. But what happens if the participant dies before reaching retirement age? This is the ultimate open loop of the 2000s. If James died in 2012 before he or Linda could collect a single Social Security check, and the 401k had already been split based on those future projections, the entire settlement becomes a ghost. In the next part of our masterclass, we are diving into the survivor benefit disaster. We will look at why a QDRO must include specific survivor language to protect an ex-spouse from being completely wiped out by a single heartbeat. If your QDRO doesn't name you as a surviving spouse for the pre-retirement period, you could lose every cent of that 401k if your ex-husband or ex-wife passes away tomorrow. We are about to reveal the dead participant trap that left thousands of American divorcees with nothing but a legal bill they couldn't pay. We will also explore the remarriage clause, the hidden rule that can strip your benefits away if you find love again before the age of 60. The survivor benefit clause is the hidden heart of a qualified domestic relations order, and in the 2000s, it was the single most common point of failure that turned a successful divorce settlement into a financial catastrophe. To understand why, you have to look at the cold, mechanical way federal law treats retirement accounts upon the death of the account holder. Under ERISA, a 401k is not a standard inheritance. It is a contract governed by specific survivor protections. If your QDRO does not explicitly name you as the surviving spouse for a specific period, you are essentially gambling your entire financial future on your ex-spouse's heartbeat. This was the era where the term separate interest became the gold standard. Yet thousands of attorneys were still drafting shared interest orders that left their clients vulnerable to the dead participant trap. Let us look at a case study that illustrates this perfectly. Imagine a character named Amanda in the year 2007. Amanda has just finalized her divorce from Thomas after 22 years of marriage. Thomas has a 401k worth $800,000. The divorce decree is clear. Amanda is awarded 50% of the account, totaling $400,000. Her attorney drafts a QDRO, but they fail to include a small technical paragraph regarding pre-retirement survivor benefits. The attorney assumes that because the judge signed the decree, the money is already hers. But as we have established, the money does not move until the plan administrator approves the QDRO and segregates the funds. This process can take months, for weeks after the divorce is finalized, and while the QDRO is still sitting on a desk at the plan administrator's office, Thomas unexpectedly passes away. Because the QDRO was not yet qualified and did not contain specific language designating Amanda as the surviving spouse for the purpose of the 401k, the plan administrator follows the only legal document they are bound by: the beneficiary designation form on file. Thomas, in a moment of post-divorce bitterness or perhaps just simple negligence, had changed his beneficiary to his brother the day after the separation. In the eyes of federal law and the plan administrator, Amanda is now a legal stranger to the account. Despite having a state court order saying she owns $400,000, the death of the participant before the QDRO was qualified means the entire balance is paid out to the brother. This historical trend of the mid-2000s led to a wave of malpractice lawsuits against family law attorneys who treated 401ks like bank accounts rather than complex federal trusts. To protect against this, savvy practitioners in the 2000s moved toward the separate interest QDRO. Let us break down the mechanics of this step by step. In a separate interest order, the alternate payee's share is literally carved out into a new, independent account within the plan. The moment this happens, the ex-spouse's benefit is no longer tied to the life of the participant. If the participant dies the next day, the ex-spouse's account remains intact. However, if the order is written as a shared interest, the alternate payee only receives a portion of each payment as the participant receives it. In a shared interest scenario, if the participant dies, the payments to the ex-spouse stop immediately unless a survivor annuity was specifically elected and paid for. In the early 2000s, many older plans did not even offer a separate interest option, forcing couples into the much more dangerous shared interest model. The 2000s also brought to light the confusion surrounding the remarriage clause, particularly how it intersects with Social Security versus the 401k. Imagine if Amanda, after losing her share of the 401k, tries to claim Social Security survivor benefits based on Thomas's record. Under U.S. law, If she was married to Thomas for at least 10 years and has not remarried before the age of 60, she is eligible for those benefits. However, a common misconception in the 2000s was that remarriage would also strip her of her 401k rights. This is a critical distinction. Once a 401k is divided via a QDRO and moved into an account in your name, it is your private property. You can marry, divorce, and marry again, and that 401k money remains yours. But if your settlement was structured to pay you a monthly amount directly from your ex-spouse pension or 401k style annuity, many 2000s era agreements included a termination on remarriage clause. People were literally trading their long-term 401k growth for a monthly check that vanished the moment they found love again. Furthermore, we must address the issue of the successor alternate payee. In the 2000s, very few people considered what would happen if the ex-spouse, the one receiving the money, died before they could spend the 401k. If Amanda had successfully moved her $400,000 into an IRA but then passed away, the money would go to her chosen beneficiaries. But what if she died while the QDRO was still in process? Without a successor alternate payee clause, the money might revert back to her ex-husband, Thomas, effectively cutting out their children. This created a secondary layer of litigation where estates fought over the intent of the divorce decree. Historical trends show that by 2009, the most sophisticated QDROs included a chain of command for the money, ensuring that if the ex-spouse died during the administrative gap, the funds would flow to the children or a designated trust rather than returning to the participant. This era of the 2000s was the great learning curve for the American legal system. We saw the transition from the idea of the 401k as a simple asset to the realization that it is a living, breathing legal entity that requires constant maintenance until the very second the funds are transferred. The case studies of this decade prove that a divorce is not over when the judge bangs the gavel. It is over when the plan administrator sends the letter of qualification. For the U.S. audience in 2026, the lesson is that you must look for the surviving spouse language in your old documents. If you were divorced in the 2000s and your ex-spouse is still alive but the money was never properly moved, you are standing on a trapdoor that could open at any moment. As we reach the final chapters of this masterclass, we have to talk about the ultimate endgame. The 401k as a tool for long-term survival in an era of disappearing pensions. We have covered the crashes, the taxes, the saboteurs, and the survivor traps. But there is one final piece of the puzzle that most people miss until it is too late. It is the role of the 401k in the division of other, non-retirement assets like executive stock options and deferred compensation plans. In the late 2000s, as corporate America moved away from traditional structures, the 401k became the benchmark for valuing everything else. But what happens when the 401k is used to buy out an interest in a business that later goes bankrupt? What happens when the math of 2008 meets the reality of 2026? We are about to conclude this deep dive with the blueprint for the modern retirement audit. How to look back at your 2000s era settlement today and find the hidden value that your attorney might have left on the table. The final part of our journey will reveal the one document you can file today to potentially reopen a flawed 401k division from 20 years ago. The document that haunts the sleep of family law attorneys and provides a glimmer of hope for those with unresolved settlements is the motion for relief from judgment, often filed under Rule 60(b) of the Federal Rules of Civil Procedure, or its state-level equivalent. In the context of a 2000s-era 401k division, this is the legal lever used to address what is known as clerical error, mutual mistake, or newly discovered evidence. For someone standing in the year 2026, looking back at a 401k that was supposedly split in 2006 but never actually moved, this motion is the first step in a complex process of judicial archaeology. It is the mechanism that allows a court to reach back across 2 decades to fix a bridge that was never fully built. To understand the power of this document, we must look at the case of Kevin and Susan, a couple who finalized their divorce in the summer of 2008, just as the global financial system began its historic descent. Kevin was a high-level executive at a manufacturing firm with a 401k valued at $800,000 and a portfolio of unvested executive stock options. In their settlement, they decided on a buyout. Susan would take the entire 401k, and Kevin would keep his stock options and his interest in a private consulting business. The court signed the decree and both parties walked away, but the crucial final step, the drafting and filing of the Qualified Domestic Relations Order, fell through the cracks of a busy law firm. By 2026, Kevin has retired, and Susan realizes that the $400,000 she expected to see in her own IRA never arrived because the Northlink 401k plan was never served with a QDRO. Under historical trends of the 2000s, Susan's lawyer would now file a motion for relief from judgment or a motion to compel the execution of the QDRO. The goal is a nunc pro tunc order, which is Latin for now for then. This order asks the judge to sign a document today, but give it the legal effect of the date in 2008. This is not just a paperwork fix. It is a battle over 20 years of market growth. If the 401k grew from $800,000 to $2 million between 2008 and 2026, is Susan entitled to 50% of the current value, or only the original $400,000? The potential outcomes depend entirely on the specific language of that 2008 decree. If the decree awarded Susan a specific dollar amount, she might be limited to that original figure, effectively losing 20 years of compound interest and inflation protection. However, if the decree awarded her a percentage of the account, a skilled attorney in 2026 would argue that the nunc pro tunc order must include all earnings and losses attributable to her share since the original valuation date. This highlights the benchmarking trap that many 2000 settlements fell into. Using a 401k to buy out a business interest, as Kevin did, was a common strategy, but it relied on the assumption that both assets would maintain their relative value. When the 2008 crash hit, Kevin's consulting business and stock options evaporated, while the 401k, despite the dip, eventually recovered and thrived. Kevin might now argue that it is inequitable to give Susan the full current value of the 401k when he was left with nothing, leading to a secondary round of litigation over the fairness of a 20-year-old deal. Step by step, the audit of a 2000s-era 401k division today requires a three-pronged approach. First, you must obtain the plan administrator's letter of qualification. This is the only document that proves the 401k plan officially accepted the QDRO. If this letter does not exist in your files, your share of the retirement may still be sitting in your ex-spouse's name, vulnerable to their creditors, their new spouse, or their own withdrawals. Second, you must verify the valuation date versus the transfer date. In the 2000s, many QDROs were written with a valuation date of the day of the divorce, but the actual transfer didn't happen for 6 months. If the market rose 10% in those 6 months and your QDRO didn't specify that you get a share of the gains, you effectively gave a 10% gift to your ex-spouse. Third, and perhaps most importantly for those in 2026, you must check for the gains and losses language. This is the technical phrasing that determines if your share of the 401k is a static snapshot or a living investment. Without this language, a plan administrator might only transfer the exact dollar amount listed in the order, regardless of how much that money grew while it was waiting to be moved. In the deep dive of 2000s litigation, we see that the absence of these 4 words, including earnings and losses, has cost American divorcees billions of dollars in lost retirement wealth. We must also address the role of ERISA Section 502(a)(1)(b). This is the federal statute that allows a participant or beneficiary to bring a civil action to recover benefits due to them under the terms of their plan. If you have a valid QDRO from 2005, but the plan administrator refuses to honor it because the company has merged or changed providers, this is the hammer you use in federal court. The 2000s were a decade of administrative friction, and Section 502 is the grease that keeps the wheels of federal retirement law turning. It allows you to sue the plan itself, not just your ex-spouse, to ensure that the federal protections of ERISA are upheld. As we conclude this masterclass, the overarching lesson of the 2000s 401k divorce is that the 401k is not a static prize to be won. It is a fiduciary relationship that must be managed. The historical trends of the dot-com bust and the 2008 Great Recession prove that the legal system is often slower than the market, and the administrative system is often slower than the law. For the U.S. audience today, the 401k represents the single largest transfer of wealth in marital history, and the mistakes made between 2000 and 2009 are only now becoming visible as that generation reaches retirement age. Imagine the 401k as a ship. The divorce decree is the map, the QDRO is the engine, and the plan administrator is the captain. If any one of those elements is missing or misaligned, the ship will never reach the port of your personal retirement account. Whether you are looking back at a settlement from 20 years ago or navigating a new one today, you must treat every sentence in your retirement orders as a potential point of failure. The technicality is the reality, the math is the law, and the 401k, far from being a simple bank account, is a complex, market-exposed, federally regulated fortress that requires a masterclass level of understanding to breach. But even as we finish this deep dive into the 401k, a new frontier is emerging. The lessons we learned from the 2000s, the volatility, the tax traps, and the administrative failures, are now being applied to the next generation of marital assets. As we move into the future, the same legal battles that were fought over 401ks in 2008 are now beginning to play out over cryptocurrency cold wallets, health savings accounts, and digital estate planning. If you found the 401k division complex, the world of decentralized asset divorce is the next great challenge for the American legal system. The blueprint we have established here, the need for federal compliance, the danger of valuation dates, and the absolute necessity of professional auditing, is the foundation for the next decade of financial survival. This concludes our masterclass on the 401k divorce in the 2000s, a decade that redefined the American retirement.